College football is back, and we're back on the Big Mountain, where we bring you a fresh take on college football betting focused on the Big Ten and the Mountain West.
How you doing again? My name is JY, and this is my good friend Steve, and we're going to throw our fourth episode out here. This one regarding the hearing that was just held on Monday. We actually did a preview video of the hearing just a couple days ago. Obviously, we've had the hearing. We know what transpired from that. So we want to give you an accurate and detailed reporting as to what occurred, what maybe didn't occur with the hearing on Monday. And at that hearing, WSU and OSU filed a temporary restraining order against the PAC-12 and its commissioner to stop a meeting of the PAC-12 that was scheduled for Wednesday of this week. The judge did end up granting the TRO, but not after some interesting presentations from both sides here. Both sides being the Washington State and Oregon State side, and then the defendant being the Pac-12 and the Pac-12 commissioner side. Some of what was said actually helped shed a little bit of light here in terms of where things stand today. And we want to summarize what the hearing was all about, what was said, and give you our thoughts and opinions on where we think things are going to be going from here. On our last episode, Steve actually had stated that he thought the TRO would be granted, which, well done, Steve. He was correct. I was a little more, I wasn't a little more. I was on the side that I didn't think they would get it, but Steve got that correct. However, it's really like a small step. It is a small step to what's going to be a much larger process that, frankly, is just in the beginning of this in terms of the legality of where the Pac-12 could be headed. I've seen this reported by like as a major victory for Oregon State and Washington State. I believe that's people pandering to their audiences. And yes, I'm looking at you, Seattle Times. I mean, that was their headline. I just think that's an overstatement of what occurred here. I will say, if you think things are kind of messy right now, we are just beginning with the mess. It is going to become a soap opera that could be shown daily. And we'll be here to hopefully help you meander through this whole process. We want to try to summarize the important parts of the hearing in this episode. The hearing took about an hour and 15 minutes in total. So let's talk about what actually occurred at this hearing. It was held at the Whitman County Superior Court, which is the county in which Washington State University resides. Yep. And both Steve and I watched the hearing. We have watched an hour and 15 minutes separately.
We watched it so you didn't have to.
There you have it. We watched it so you didn't have to. And we want to summarize what went on here. So we're going to break it down into three kind of segments, if you will. The first segment being the OSU and WSU attorney addressing the court. And then we'll talk about the Pac-12 attorney addressing the court. And then obviously we'll talk about the judge's ruling, which got kind of interesting at the end. A little bit of tidbits that I think that I definitely want to talk about as that kind of ended the entire hearing. So before we start here, Steve, anything you want to add there?
Yeah, I would just say with what you said, we're at the very beginning of this. If this is if I'm expecting this to be a 10-round title fight, we're still in the first round, and this is the first time that the referee kind of came in and did a break to break the fighters apart.
Right.
And that's how much longer I think we have to go.
Great analogy. Yeah. Great analogy. So let's start with Eric McMichael's statements. He is actually Oregon State University's legal representative or attorney, and he argued for the plaintiff here. He was the only one to speak. And he was arguing irreparable harm for both OSU and WSU.
If they had the meeting on Wednesday.
Correct, if they would have had the meeting. So that's kind of, and we talked about that in the last episode, that was kind of the hurdle he had to get across was, will there be irreparable harm if the meeting occurs? So that's where he won. But before he got into that, he did a little history lesson. So again, I'm going to summarize here a little bit of what was said. I think some of it's important, especially he went through some dates that I found very, very interesting. I'm sure you can find this in reporting if you want to go back and read a whole bunch of articles of when these things went down. But we're going to summarize this here real quick because I think it's really important. So obviously critical is that last summer USC and UCLA were no longer attending board of director meetings and voting. Now, again, everything I'm going to be reporting right now is coming from the attorney. So, to him, it was critical that occurred, and they no longer were attending these meetings. The same then occurred with Colorado, effective July 27th, when they were no longer allowed to attend board of director meetings or have a vote. Those points that I just bring up are going to be countered a little bit later when we get into the Pac-12 attorney. He's going to counter that a little bit. But let's move on here with the OSU attorney. He cited a letter that was written to Colorado by the Pac-12 conference on July 28th, so a day after Colorado publicly came out that they were thinking about or going to be leaving. And that letter from the Pac-12 conference notified Colorado that they would lose their right to attend board of director meetings and vote. This, to me, is going to be one of the key facts moving forward, in my opinion. I mean, I think it's interesting to hear that a letter came from the Pac-12 to Colorado telling them you can no longer vote.
And that was from the Pac-12 office, the office of the commissioner of the Pac-12.
Correct. All Colorado did at that time was send an email to the commissioner telling him that they were going to be voting on joining the Big 12.
Yep.
So, again, it's going to be a he said, she said, and or what does withdrawal really mean? But I think it's important to note that Colorado sent an email to the commissioner saying we're going to be joining or thinking about joining the Big 12.
Yes,
it wasn't about withdrawing at this point,
right.
Withdrawing from the Pac-12. Now, you may say, well, it's one and the same. Legally, I don't think it is one and the same, in my opinion.
It's important to note that email was prior to their public announcement that they were leaving, that they were going to the Big 12.
Right, yes. So then on August 29th, so a little time passed here, about a month passed, the commissioner asked the board president Schultz, who was also the Washington State University president.
It's ironic.
Ironic, yes. It is very ironic, actually. It's kind of weird how that, well, I mean, it's not weird. It's kind of telling maybe how that all works. But anyway, he asked Schultz to call a meeting to invite all 12 members of the Pac-12 to have a meeting. Mm-hmm. Schultz did not do this. He declined to send that email.
I think in that timeline he said that not only did he decline, like he didn't just not do it, he declined. He replied and said no.
Correct. He refused.
Because they are not voting members.
Correct. So, he refused to do it. Again, remember that as we get into the Pac-12 attorney's claims here, because that's something that will come into play here again. Later that day, the commissioner then, because Schultz did not, the commissioner then sent an email to all what he called CEOs, which they wanted to make a big stink about, but whatever, presidents, CEOs, whatever, of the conference, having a discussion on important issues. Again, not an agenda necessarily, not even a voting meeting, but a discussion on important issues. Again, something else that's going to come back here later in our video. On August 31st, another email from the commissioner was sent to all 12 schools trying to get a mutually agreed upon date that they can have this meeting. This is August 31st. On September 6th, so this is now just a week ago, September 6th, another communication stating that the Pac-12 planned to have a board meeting with all 12 schools being invited was sent, and here were the three things that were said to be discussed at this meeting.
And this was, just to clarify, this was the first time that it had been called a board meeting. Before, it was just a meeting.
Correct.
This is
a
the first time it was
meeting.
Board meeting.
Right.
Yeah.
Correct. This was a board meeting, again, a week ago. The three things to discuss: a retention plan for all employees. Makes sense.
Yep.
Revised scope of services for the year. That basically means a revised budget. They kept calling it a scope of services. It's a budget. So if you hear us say scope of services, it's their budget. Revising the budget.
They're governing their interaction with people they have contracts with, the outside, the TV partners, other partners.
And then the one that he had the most issue with here, amend the bylaws regarding a conflict of interest policy.
Yeah.
Definitely doesn't look good. I mean, I definitely understand where OSU's at. What are we talking about? You're bringing in their opinion, non-members to talk about a conflict, a change, and an amendment to the bylaws for a conflict of interest. Definitely not a good look there, for sure. Yeah. So that was his first topic, just kind of laying out a history lesson, so to speak, on what occurred. His second topic then was that of the likelihood on success of merit. Here he questions if the schools that provided, in his opinion, the notice of withdrawal, if they still had the right to vote. It should be noted that it was never said in this hearing that the 10 schools that are withdrawing, or that are, I don't want to say withdrawing yet, because in their mind they're not. The 10 schools that have publicly said they are looking to leave and join other conferences. It was never said that a notice to withdraw, a formal notice to withdraw, was ever sent to the PAC-12. I think that's very important here. Again, you got to really have your I's dotted, your T's crossed with some of this stuff, especially when the bylaws are ambiguous. They're not very decisive.
Yep.
So it's going to come down to opinions of attorneys and ultimately a judge at this point. So he stated that this question, the question whether or not these 10 former members, the treasonous 10, as I've heard them called, or I've seen them called, the treasonous 10, should be able to be at these meetings. He started then to argue what a withdrawal is, and he went back and forth. Spent about 20 to 22 minutes on this whole back and forth about that's the withdrawal. That's not what this hearing was for. I'm not going to get into that. It was frankly a waste of time. That's not what this hearing was about. This hearing was about a restraining order, period. But anyway, he finally got to his third point. His third point being irreparable harm, which is what this hearing is finally about. So he had a history lesson. He had this whole 20-minute conversation about likelihood of success, which frankly is irrelevant in this. He didn't obviously think so, but my opinion was irrelevant, was a waste of time. Then he finally gets to his third point, that of irreparable harm. He stated that to him, this was self-evident that there must be a decision on who is lawful members prior to any further meetings. So we can't have any more meetings until we know who is an actual member. Is it 2? Is it 10? Is it 12? Yep. Is it 9? Nobody seems to know that. Stated that he also stated that there is strong financial incentives for the 10 schools leaving the conference. He stated there is a conflict of interest for all schools leaving the conference. And then he stated, and this was a key point for me, he stated that there is a possible budget revision to allow PAC-12 to pay the transition costs of these schools that are leaving the PAC-12. Now, I don't know if that's factual or not, but he made that comment that in his mind and in his client's mind, that some of that budget revision, which was on the agenda, was to revise the budget to pay for transition costs of these 10 schools. That's pretty damning if that's true. Now there's no I don't know if there's evidence of that, and that's not what this hearing's for. But that was a key statement. That was one of the things I was like, oh wow, listen to that. That I took away from.
That would be huge.
That would be huge. The judge then asked about a joiner of the other parties, meaning, hey, this is you two versus the PAC-12 and the commissioner. What about the other 10 schools? Having a joiner to bring these other parties in. That was stated a couple different times. Again, that's not something for this hearing necessarily, but absolutely that's what will happen moving forward. I mean, the beef here is really between the schools more so than it is the PAC-12, and we're going to get into that with Mr. Lambert, the attorney of the PAC-12. Just to wrap up there, McMichael then stated that other parties were not necessary for this TRO, which I just said, that obviously makes sense. It wouldn't be necessary for this. However, Oregon State and Washington State did provide notice of this TRO to the other 10 schools on Saturday, September 9th. I don't know what time of day, but 48 hours-ish before the actual TRO. Not a ton of time. And that's when the PAC-12 got it, too. So the PAC-12 attorney had, I'm going to say 48 hours. It likely could have been less to prepare for this hearing. He then McMichael finished with another lengthy statement about who the true members are. He really was just focused on, in my opinion, the wrong thing at the wrong time, but I think he was trying to drive home that point. It's his first time in front of a judge to talk about that. He certainly got that across. Let's stay focused on the TRO here, though, please. So that's where McMichael was. Anything you want to add, Steve?
So I would say, well, first of all, I think, the timeline was interesting because a lot of those dates are public dates, but he added some context to them that maybe wasn't publicly available.
Correct.
So I thought that part was really interesting. There is a component, so there's two components to this. One is to show that there could be irreparable harm.
Right.
The other is to show that it's a legitimate case, that you could win it. If it's just some crazy cockamamie case. And so I definitely understood why he won it, but he went really, really, really far.
He went very
into
far.
the weeds on that. And I think the judge, from some of his questions and things, the judge didn't want to get that far down
Correct.
in the road at this point. But I do think he did a very great, very succinct job of explaining the irreparable harm from the perspective of Washington State and Oregon State.
Right.
Which that's really all he really needed to do.
Right.
And the judge was ready to grant that temporary restraining order. Overall, though, I think it was a good presentation. It was a good first punch.
Yeah.
But it was maybe he might have shown a little too many of his cards at the beginning.
Yeah.
Than he needed to.
Yes, I agree. And if you thought that was good, I actually think what Mr. Lambert said
Let's talk about that.
to be even better. So let's get into that. The Pac-12 attorney, Mr. Lambert, then took the podium about halfway-ish through, a little more than halfway. McMichael was slightly more long-winded again, getting into the whole member issue. But Mr. Lambert then started by saying that the Pac-12 and the Pac-12 commissioner answer to the board of directors, obviously. And they are currently stuck in the dispute between their members, and they just can't agree who can sit on the board. So that really, I mean, it's obvious, but I think people forget that. Like I see a lot of people throwing hate towards the Pac-12 and specifically the commissioner. And I'm not here to exonerate the commissioner whatsoever, but I do think we need to understand that our issues here are between board members.
Yes.
And the Pac-12 is in the middle of that, trying to get through a season here.
Yes.
And that really is going to be Lambert's kind of go-to here as he speaks. He urged the court that the retention agreement, again, item number 1 that was on the agenda, has to be ratified so that the Pac-12 employees, to which there's about 196 they referenced, I heard 196 at one point and 192, but we'll say around 200 employees, that are essential to the day-to-day operations of the Pac-12. Because remember, we have a whole school year here to get through. We have a whole football season, winter season, spring season. Like, life is going on here, and we need to have a Pac-12 conference in order to do our business.
And he made mention a few times, and sorry to interrupt, but of how many, I forget the number, but of how many student athletes are going to be competing in seasons, already competing, and will be competing all this year, which was great.
He mentioned 7,000, and I'll get to that. Yeah. He said 7,000 student athletes multiple times. So again, as you said, the OSU, WSU attorney was focused on the harm to them. It was interesting to see how Lambert kind of, and he didn't do it aggressively. I thought he did it very tactfully. How the harm really is to all of the universities for this year, all of the student athletes for this year. I mean, it was compelling to me to hear him say that. So anyway, and the retention agreement here was the single most important issue for the Pac-12.
Yes.
100%. I mean, he was adamant, and you're going to hear me say this as we go through this. He was adamant that this retention agreement has got to be ratified. The conference then obviously must keep functioning for the student athletes for the current year to serve all the members. The budget agenda item, again, the second item on the agenda, he said was a mischaracterization, at least what OSU and WSU were representing it to be, was a mischaracterization out of suspicion, is how he put it.
Right.
Which, throw a couple punches back at him here, right? What's right, what's wrong, or what the truth is, who really knows? But that's what he said.
Yeah.
He went on to say 10 members hotly dispute the conference's statement about the bylaws regarding withdrawal, but also whether they actually gave notice. And now this is the Pac-12 attorney saying this. This isn't Colorado's attorney. This isn't Arizona State. This isn't Utah. No. This is the Pac-12 attorney saying. He wouldn't have to say that.
Yeah, he's saying they dispute it. He's not saying he disputes
Correct.
it. He's saying
again, the Pac-12 being in the middle of this.
Yes. Yeah.
So these 10 members dispute this withdrawal, or how the withdrawal wording is being used by OSU and WSU. And trust me, I know we've had comments. Now's a good time to say this. We've had comments of our others. For you Washington State fans, for you Oregon State fans, please, Steve and I feel horrible for you as fans, for you as universities, for you as a community of what those universities are. We know what that is. Steve was in the Navy. I went to a university. It's a community there. I'm not saying any of this to knock these communities, these families, these universities. We're just trying to provide the information, trying to give you our opinions in terms of what was actually said. It's not really my opinion saying that you're wrong and you're not going to keep your PAC-12. That's not what I'm saying. We're trying to be kind of unbiased bystanders here and just give you our opinion. So I thought now was a good time to kind of mention that. I mean, certainly put whatever comments you want in there. Certainly you don't have to agree with our opinions. We love getting your comments, but nothing against Washington State and Oregon State on this.
It's a high emotion issue.
Very high.
You have all these student athletes that are affected. You have people who their jobs at Washington State and Oregon State could be affected by this, and at the PAC-12. So it's definitely an emotional issue.
And he went on to say this is an issue between board members, which is exactly what it is, between universities, which are the board members.
Yes.
This is a school issue, not a conference issue.
Yeah.
Now, I know people in the Pac-12 would say, oh, this is a conference issue, and our commissioner is the one that caused all of this. And, through media rights deals and negotiation stuff, you may very well be true. And that was forced for them to leave.
Yeah.
But in terms of this withdrawal issue, it is 100% a member issue.
Right.
The third item then were the bylaw amendments, which again to me was the one of the three items on the agenda that I could fully understand Washington State and Oregon State saying, hold on, time out. What are you talking about?
Bylaws, yeah.
How are you changing bylaws here? I mean, again, that's the one that really confuses me. The budget one a little bit, but certainly the bylaw one. He again says it's a mischaracterization. I think that's legal mumbo jumbo, but a mischaracterization. There was no dissolution motion on the agenda. The judge did push back on that and say, well, what's to keep any member from bringing that up? Which is a great question. I mean, when you're in a board meeting, you can bring motions from the floor. And he didn't really have a response to that. He just kind of said, well, we wanted a frank discussion. And it gets back to the letters that we talked about. Originally, the letters that went out saying, hey, we just want to have a discussion. Not a board meeting, but a discussion. So again, they're kind of saying the same thing, but they're saying it from different viewpoints here that makes the other two look bad.
I had that part in my notes, and I was going to say something when you were done.
Go for it.
Since we're talking about that part now, I thought that was his weakest moment by far of the entire hearing was the judge pushed back and said, well, what's to keep them from changing the bylaws or doing this or just saying we dissolve today? And he said, well, we're hoping that everybody would come together.
Right.
And the judge was like, yeah, well, that's hope, but what guarantees are there?
Correct.
And he was just like, well, we would think that when they got together, they'd come up with a good decision. So he had no answer for that, whatever. And because there is no answer to that, because there is nothing that would keep them from doing that. So.
Correct. Right. And I think that was it was the weakest part for him.
Right.
But it was also the reason why this TRO was granted.
Exactly. Oh, absolutely.
It's exactly the case that we're talking about.
And I think he kind of stepped out on a ledge with that because he did mention a few times about where I don't want to say he was advocating for those other 10 schools, but he was kind of giving their point of view.
100%.
And so when he did that, he kind of stepped out. The judge is like, okay, well, if you're saying this, you're saying what they plan to do or don't plan to do, because he's saying that's a mischaracterization.
Yes.
How do you know that? And what's going to prevent that? So he did a great job, but I think that was really his weakest moment. And he stepped out there, and the judge kind of slapped him a little bit.
A little. Well,
not really,
he
but
called him out for it.
He let him step in his own.
He did. And I completely agree with you. He did more talking for other members, not advocating for them, but at least telling their side of it.
Yeah.
But then purely, I'm just answering questions about the Pac-12.
Right. But when he says that the plaintiff statements about what the other members plan to do were a mischaracterization, he's basically speaking for them.
Absolutely.
Because how does he
You
know
don't know.
that?
Yes,
Exactly.
right, yeah. So then Lambert goes on and stated that, as we discussed, they served this on a Saturday. The hearing was on a Monday. Obviously, he's not surprised at all that the other 10 would not have a meaningful response. 48 hours later, the judge was very complimentary to both attorneys, specifically of Lambert, of providing the information so quickly. It was then further discussed in terms of enjoining the other 10 members, which clearly is going to happen as we move forward. He did feel that the other schools were strategically omitted from the filing, which he deemed disappointing. Okay, they got what they wanted, so I don't think SMU and OSU and WSU really care who was admitted and who wasn't admitted.
Right.
But anyway, and then he also stated the issue between some of the schools being public and private, and you actually brought that up the last time.
It's a huge factor.
Yes,
massive.
And again, not what this hearing was for,
right?
But just another piece of what's going to be this huge war, mess, saga, whatever you want to call it. The public-private issue is going to be and he briefly touched on it. Lambert then got into, and this is where, to me, the best part of the whole hearing was. So if you stuck with us this far, thank you. Here's where, to me, some of the most juicy information is going to come. So he got into USC and UCLA and where things might head as we move forward through the court process. Again, I found this very interesting. He says, evidentiary record shows a dispute in the conference. USC and UCLA clarified they were not withdrawing in June of 2022. At this time, there was a media rights deal that they hoped would help save the conference, basically. Like they were in this media rights deal. They wanted to save the conference. It lasted a while. And that was the main reason why USC and UCLA were not really involved at the board level, because why would you involve these two schools that really have no skin in the game when it comes to future media rights? And that's why they weren't involved. Makes sense to me.
It does, but I think there's a little danger there.
Okay.
I think there's a little of trying to have it both ways, because on the one hand, he argues, no, USC and UCLA were disputing that they didn't have the right to vote. They wanted the right to vote. But then he says they went ahead and basically says voluntarily that I think he calls it a détente.
Yes, he did. Yes, he did. Yes.
To go ahead and step away because of the media deal and the hope that media deal could keep the conference together.
Correct. Right.
And so they voluntarily did that before, and so there's a little bit of risk in that, because the judge could say, well, if they were willing to step aside before in the hope to keep the PAC together, and they did that, why wouldn't they do that now when Oregon State and Washington State is trying to keep that conference alive?
And to me, the USC UCLA thing is frankly a non-issue. I think you just say they don't have a vote. We're now a PAC of 10 and maybe 9, because I'm going to get to Colorado next. Maybe we're a PAC of 9, and I totally could understand that 100%. I hear what you're saying. I totally understand what that would mean. The next item that happened then is Colorado. The media rights deal still going on when Colorado announces that they're looking to leave the PAC-12. Then, when no media rights deal ever occurs, that's when the other 7 then announce we're going to leave as well. Now, to get back to your point, for me, I get that with UCLA and USC. It's been a year. If that's what they did, and that's fine. We're now a PAC of 10. With Colorado there in, what was that, June, I think, of 23. Was it early July? I don't remember. But, okay, maybe they're going to do the same. Colorado's going to follow in the same footprints because the media deal was still ongoing, or the media negotiations, discussions. Okay, so now we're down to a PAC of 9. But then when that falls apart, we're still a PAC of 9, in my opinion. Well,
here's the problem, though, is they had met the day that Oregon and Washington said they were leaving. That morning, they did it after that morning. They had a meeting about the new media rights deal with Apple, the proposed. So it gets it. I see where you're saying. Okay,
Yes.
USC, and UCLA are cut and off.
They've already been gone.
That makes sense, but then the problem becomes, where do you draw that line? Because it was so mixed and muddled.
It was mixed
back
and
forth,
and it happened very quickly.
Very quickly.
It happened within a month, 2 months, whatever. I mean, it was very quick.
At the very end, it was within days and 1 week where they were going back and forth, and the commissioner was trying to drag them back in to vote to approve this media deal. And so that gets messy, which that's going to be a further messy issue going forward.
So the two big things that then he stated, again, this is opinion, but he stated that these 7 schools, they were not giving a notice to withdraw, but that they were planning on joining other conferences. Now, I get it. Some people are going to say, well, if you're planning on joining another conference, that means you're withdrawing.
Right.
That's for the hearing. I'm not going to get into that right now, but in their minds, I can tell you, those 7, 9, 10 schools we have not given our notice of withdrawal. We have just notified you that we're looking at or even joining another conference, but we're not withdrawing today from the Pac-12.
Mm-hmm.
So on June, and then here was the other wingdinger that he said. On June 24th, President Schultz came up with the idea to bring all 12 presidents together for a discussion. Now, if you remember, back to the beginning of the video, it was the commissioner asked Schultz to do that. He's now saying it was Schultz's idea to bring them together to see if they couldn't have a discussion. Not a voting meeting, not even a board meeting, but a discussion on what could move forward. He then said that was later retracted. So to me, that was big. I don't know which is right and which is wrong, but if Schultz requested that meeting, that does not look good for Washington State.
Yeah,
in my opinion, because that was a big piece to McMichael's comments.
So some of the problem there is, and one of the items on the agenda was revising their conflict of interest.
Right.
The way they're constructed. So if Schultz did request that meeting, was he acting in his capacity as the Oregon State president, or as he's the board president, the board of trustees president for the PAC-12?
Right.
And so there's all kinds of conflicts of interest.
Yes, right. Absolutely. Yeah. Then just to wrap him up, he went back to the retention agreement again, saying how important this was. They have to get it ratified. He ended with an alternate proposal. He actually handed out an alternative proposal. It didn't really go anywhere.
Proposed ruling.
Yeah. Then he ended with some statements. He said, there's no doubt that the member issue must be determined. There's no evidence that a dissolution motion or payments was going to occur at this meeting. He again pushed for action on the retention agreement for employees. He stated that harm, and this gets back to what you had talked about, that harm could happen from the Pac-12 side to the current season, to the 7,000 plus student athletes, and just the inability to perform and keep the conference running for the next 11 to 12 months. To me, that's legit harm here.
Yeah, absolutely.
He then reminded everyone that the entire conference of 12 has a current and common interest in this year's revenues.
Mm-hmm. Which, did you get the number, what that was?
500 million.
500 million.
500 million. Year. Yeah. So then he just, again, said that the commissioner has not taken a side. He's not trying, what he's trying to do is steer a troubling ship, is how he put it, which makes sense to me. Again, I know there's strong feelings about the commissioner, but they've got to figure out how to get through this year. Yeah. And again, without this retention agreement, they could hemorrhage employees very fast.
Yeah.
So go ahead and then we'll get to the judge's ruling.
Before we get to the ruling, so the first lawyer, I forget his name, the Washington State
McMichael.
McMichael.
Yep.
I kind of, that was like a tale of two lawyers there. There was one part where I think he did excellent. There was the other part where I think he just got way too deep in the weeds.
Yep.
And the Big Ten lawyer, what's his name?
Lambert.
Lambert. Okay. Same thing. I think he did an excellent job advocating for the student athletes.
Yes.
And saying how this not having the meeting would affect the student athletes, would affect their season.
Right.
He did an excellent job for that retention, explaining.
Yes.
And was insistent.
Yes.
Multiple times and explaining to the judge how not having that retention agreement could basically just blow up the whole thing.
Absolutely.
And it could destroy their revenues for this year, could destroy the seasons of all these student athletes, and not just football. We always focus on football.
Correct, right.
But the Pac-12 has like 20 different, over 20 different sports.
Right.
So that's a lot of student athletes. He did a great job with that. Excellent job. And as we get to the ruling, you'll see that some of that paid off with him being persistent with that stuff. Now, what I will say is I think there was a few times where he stepped into that danger zone and tried to have it both ways, because he made a very strong point at the beginning, like you covered, that he was there representing the conference and the commissioner,
correct,
and that those other schools were not named in this, and that they should be named in it so they could make their case, because he wasn't representing them. He was representing the conference, and they were in the middle, and they're trying to play neutral arbiter.
Right.
Well, he said that, but then he went out on a limb a couple different times to advocate for the positions of those other 10 schools, or at least contradict what the other lawyer, and he didn't need to do that. He really didn't need to do that. And then I will say also, he almost kind of stipulated that when the judge asked him, like I mentioned earlier, when the judge asked him what would keep them, he had no answer prepared for that.
No,
so
that's true.
he basically just waved the white flag that, there should be a TRO, because I've got no answer for you. So I think, but he did a great job, again, advocating for the conference, and he explained it in a great way that I didn't think of ahead of time. Is those schools and their coaches, their athletic directors, their student athletes, they're still invested in the Pac-12.
100%.
This year, until the end of the year, they're out there on the field of play. They're on TV. They're bringing in revenue. Those players are going to bring in $500 million for this conference this year by going out and playing and doing these things. So those players should be represented in some way, and the way that they're represented is by their university, by the council of their university, and so those universities should have a say at the table. He did an excellent job of that, but there were a few times again where I think he just kind of went out on a ledge and maybe stepped in it a little bit.
Yeah, I didn't view it that way. Maybe a little bit, but I took it more as he was countering because they weren't there.
Right.
He was countering some of what was being discussed by the plaintiffs here and some of what they were saying. And I get what you're saying. He was talking for them, but I viewed it more as he was trying to paint an overall picture of it more than a one-sided picture. And quite frankly, I enjoyed it because it gave us some more information.
It was good. Yes, it was great. I just think from a legal strategy perspective, he undercut his own argument.
Sure.
Because he's making the argument they need to be represented, they need to be here because I can't represent them. However, let me go ahead and represent them and fight against... I think there was some landmines there.
Good point.
But overall, I would give him an A-.
Yeah.
And like you said, the judge complimented him multiple times.
Yes.
And I agree with everything the judge said. He did a great job in a short period of time.
Yeah.
And so let's get to the ruling. Because I think both sides got something that they wanted.
Correct. So the ruling originally was the judge was going to grant the TRO, which he said makes everyone equal, in his words.
Yeah.
And he was basically going to give it kind of. Now he made a few little adjustments. He crossed something out here. He made a couple of. It was something about you can continue business as normal. Well, no kidding. You're going to continue business as normal. What are we talking about?
Well, because the proposed, and we didn't really touch on this, but the proposed ruling that the plaintiffs submitted was that a complete freeze on all assets. So they wouldn't even be able to pay anybody.
Oh, that's ludicrous.
Right. And so the judge took that out right away.
Right. That was the piece that, he struck something immediately.
That was the part, was that they could continue business, get rid of that freeze all assets, and they continue normal business.
Okay. And then this is where, again, it got kind of interesting. And Lambert was, as politely as possible, imploring the judge.
Twice.
It did happen twice. Yeah. He did it once. And the judge kind of said, you're able to maintain business. That was kind of it. Yeah. And then he came back. The judge, I think, was at that point standing up to
ready
leave the courtroom.
He said, I'm giving this to my clerk.
He was ready. And again, Lambert says, Judge, I must implore you to listen about this retention. What we really need to get this in here. This can't not happen. now or
Yes.
on Wednesday or this week,
Has
right?
to happen.
It's got to happen. So, and then finally the judge agreed after a little back and forth, and the WSU attorney also nodding and saying, yes, we would agree to this.
If it's unanimous.
If it's unanimous. Yeah. So what he added, and I wrote it down here in quotes, the way he wrote it, what was added was, if members agree unanimously on any subject, then such actions may be adopted. Mm-hmm. And then you picked up on the part at the even after that, it was at the very end of the meeting where it didn't have to be in a meeting. It didn't have to have a voting meeting. You didn't even have to be together. It was just written approval, either via email or whatever it may be, where it says, do the members agree to this retention agreement? And as long as it's a unanimous unanimous vote, they can move forward with it.
Yeah, Mr. Lambert, he interrupted at the end and he said, just to clarify, so that we're not in violation of this TRO. Does that mean it can be done in a meeting, or can it be done by email or something like that? And the judge said yes, email, and the OSU lawyer nodded and agreed.
I don't think he would have had to have said that.
No, I don't.
I think they could. I think they could have had a meeting for that specific purpose only, and it would have gone through.
I think so. And so he was
overly cautious.
He wanted to make sure they were not going to get in hot water.
Yes.
Because if he didn't clarify that and they had a meeting and the judge was pissed off, then that could...
Right. So, but that wasn't the original...
No.
To me, that wasn't what was originally going to be put in. It was, you can have the meeting for that item, or for any item that's unanimously approved.
Yes.
And he then put the stipulation on... we don't have to have a physical meeting. It can be a email written meeting. Now, do you have anything else on that? Because I want to get to something here where I think a door was opened.
Can I? Oh yeah. So
go ahead.
I want to just push on that point that he did a great job there all the way to the very end to get that, to advocate for the conference, for the student athletes, and for the employees of the Pac-12.
Yes.
To get that part in there. And then what I will say too, I want to say one last thing about the judge. Yes, Washington State, they filed this in their little community courthouse.
He made a comment about 3,000 people,
3,000
and there's 3,000 people in this room or something.
And so obviously they're looking for they wanted to file in a place that would be friendly. They're looking for a friendly court.
Yeah.
And they did get that TRO that they wanted. So, there are some Seattle Times and some places, said it was a big win. However, I really thought the judge did a good job. He asked the Mr. Lambert multiple times, if I rule this way, are you okay with that? He definitely seemed like he wanted to find a middle ground, and he was willing to. He wanted to find something where both sides could get some kind of victory, and feel like they got a win, but they both got something out of it.
Which was surprising to me that Lambert had to ask twice after he granted the TRO. Because I thought, I was right there with you. I'm like, he's going to grant this. He's going to allow them to do these one or two things that they have to do.
Yeah.
But Lambert had to push him twice after his kind of final ruling, if you want to call it that. Yeah. That really surprised me.
Well, I think he was amenable to that. Like, the judge was like, oh, yeah, okay, that sounds reasonable. And if you notice what the judge said, so he said, I do divorce proceedings all the time.
Right.
And so I put something in here usually that says, in a divorce thing, you may go about your normal routine business, spend money. So here's the thing: is that this is a small town judge. I'm sure he's never had a case of a conference that's going to have $500 million of revenue trying to figure out their assets. So overall, I think nothing's ever going to be perfect, and definitely they filed there to have a friendly court.
Absolutely.
But overall, I think both sides got something that they want.
I think at this point, it's the best that could have happened. Even though, again, the headlines are OSU and WSU won their battle, and they did. They got their, and probably the right thing to do. It'll make it less. It's still going to be super messy, but it'll be a little less messy because of this, which is good. And I think the Pac-12 attorney admitted that. We have to figure... Well, he did admit it. We have to figure out our member issue. Now, if I may...
Yes, sorry.
Say something a little...
controversial?
A little controversial.
Hot button?
Hot button.
Okay. Get people fired up.
Well, I wonder if by allowing... Now, I know it's not a true in-person meeting, but there's still... He has now allowed a vote of 12. I wonder... what kind of precedence that's going to set. Because if I'm the OSU and I want to be if I'm McMichael and I want to make a hard line, which is what they have been doing. They want a very hard line on who is a member and who is not a member. We have now set a precedent, Steve, on this. I don't care if it's a written, I don't care if it's an email, I don't care if it's in a physical meeting. We have set precedent that 12 people are able to vote right now.
For now. So
right now.
That's a great point. Now, he did multiple times. The judge added the caveat of, we will do this. This is the judgment until there is a ruling on who the members are and who can vote. And then even ask them about scheduling and how soon they could do that. Because they both want it done as soon as possible.
They want it to get, yes.
So I agree with you. He did open the door and set a precedent. However, he put a limitation on that. Was all 12, if they agree unanimously, can vote on something now until we have that hearing to decide who is in and who's out.
Okay.
So
makes sense. I still worry because in my what I do for a living every day, we're always very focused on, is this precedent setting?
Yeah, same here.
And once it is,
yep,
it's hard to put the worms back in the jar, or whatever the heck the analogy is for that. So that was the first thing I thought of. Ooh, there might be some precedents here. Now, is it going to be the same judge? Is it going to be in the same courtroom? You've talked about it going to federal court because we're talking about 12 schools in how many different states? I didn't look, but several different states.
9 different states.
We're talking about private versus public. There's just so much detail here to have to work through. And to your point about this judge being, I won't say biased, but
he's friendly to
he's a friendly
local judge.
Friendly local judge.
Washington State.
And even to hear this that quickly, judges are smart, but you've got to have some sort of knowledge of what this all means in order to make these decisions. So, I mean, I don't know if you want to hit on that federal piece or not, but I know you've mentioned that a couple times.
I'll touch on 2 quick things, and then I'll be done for this episode. One, I do think that there's a chance that those other schools will push to move it to federal court.
Yes.
Because laws in California are different. Contract laws are different in California, are different in Washington State, and in the state of Oregon, the state of Utah. And this is really the conference and their bylaws is a contract between entities, a business contract between entities that crosses state lines. So it would make total sense if they tried to move it to federal court if they thought that was an advantage.
Right.
So that's my first point. My second point is there was a lot made of getting those other schools a part of this. Mm-hmm. There's a part of me that thinks some of those schools may not want to be a part of it. So we're dealing with public entities. Washington State is a public school in the state of Washington. The University of Washington is also a public school. I don't know that they want to be parties against each other. Because it may violate. So the board of trustees at Washington might not let their president become a part of this because it possibly could violate state laws. We have certain state laws in Pennsylvania where those are public entities. Like 2 public entities can't sue each other in the state of Pennsylvania because it's a conflict of interest. It's the taxpayers' money of the state versus the taxpayers' money of the state. So there are massive details to be worked out with these public universities. And one of them, in California, the state almost stepped in and stopped UCLA from moving to the Big Ten. There was a settlement where UCLA has to, some of the money UCLA is getting, has to be transferred to Cal Berkeley. That was the only, otherwise the state was going to stop them from going to the Big Ten. So that just opens in all these different states. It opens another ball of wax. Into politics and all that kind of stuff. So I'll leave it there. That'll be for future episodes we can talk about. I mean, there's nothing more fun than mixing sports, money, and dirty politics.
It always comes down to one of those 3 things. Well, maybe not sports, but certainly dirty politics and money. Something's always tied up in one of them. Anyway, really good thoughts to end us here. Hey, if you made it to the end of their episode here, we really appreciate it. Wanted to get through that maybe a little quicker than we did, but just had a lot of thoughts and opinions that we wanted to get out there. Leave some comments. Especially if you're the Oregon State, Washington State fans here. Let us know what you're thinking. Happy for you that maybe this is going to get worked out in a little more orderly way, even though it's still going to be a messy divorce, maybe a little more orderly than if this wouldn't have gone through. So with that, hey, we thank you for watching, and we'll see you next time on The Big Mountain.